Hello, my name is Rick Traffas, and I'll be talking to you today about administrative agencies, which is Chapter 19 in your textbook. Administrative agency is a federal or state government agency. They are considered the backbone of administrative law. They are tasked to oversee or implement specific legislation through the creation of policies and procedures or rules and regulations. For example, the Environmental Protection Agency oversees the Clean Air Act by establishing rules and regulations for companies to follow in order to make sure that the Clean Air Act is followed. The National Labor Relations Board oversees the National Labor Relations Act, which helps to facilitate interaction between employees and employers. I'm going to speak to you today more in depth about the National Labor Relations Board. During the Great Depression, employment was rampant and people had no labor protections. I'm going to show you a quick clip that highlights some of these.
29. The financial house of cards collapses, and the overinflated stock market plunges into a Great Depression. A financial panic grips the world. For the majority, it means the interminable line outside factory gates, desperately hoping for a job that rarely comes. It means hunger and the march of the unemployed in the nation's capital. With acute domestic problems, America would now isolate herself more than ever from the international scene. It started in America, but practically overnight an economic blizzard swept the world. In Japan, France, Britain, always the unemployed, the soup kitchens, the grinding poverty, and the despair.
Okay. In order to help labor gain more of a voice, the National Labor Relations Act was passed in 1935, and the National Labor Relations Board was created. The board is made up of 5 members who are appointed to the board by the President of the United States. These board members must be confirmed by the United States Senate in order to sit on the board. Immediately after it was passed, the National Labor Relations Act was challenged by various groups, seeking to have it called unconstitutional. In 1937, a case made it all the way to the Supreme Court. The case of the National Labor Relations Board versus Jones and Laughlin Steel Corporation. In this case, the court ruled 5-4 that the National Labor Relations Act was constitutional and is a part of Congress's power to regulate interstate commerce. The court also ruled that employees had a right to organize and that the prevention of this right through discrimination or coercion should be considered illegal, or was considered illegal. The Supreme Court also ruled that the National Labor Relations Act did not violate an individual's Fifth Amendment or Seventh Amendment rights, which are individuals' rights in criminal cases and civil cases. So what does the National Labor Relations Board do? Well, they help to organize employees to organize into unions or to decertify existing unions. They help investigate charges of unfair labor practices and help to facilitate settlements between employees and employers. There are 40 administrative law judges along with a 5-member board that help to decide cases. In order to enforce these rulings by the board and by the judges, there's a general counsel who seeks enforcement through the U.S. Court of Appeals. The article that I'm going to talk to you about today is called Companies Challenge Labor Rulings. In the article, 87 companies were challenging rulings made by the National Labor Relations Board. These companies are trying to reverse or stop union elections, reverse penalties ordered to be paid to fired workers, or to haul subpoenas by the National Labor Relations Board into the companies themselves. What grounds do the companies have to challenge the rulings? Well, in January 2013, a case was argued before the Washington, D.C. District Court, the U.S. Court of Appeals, by a company named Knoll Canning Corporation. Knoll Canning was seeking to overturn a decision made by the National Labor Relations Board by arguing that the board did not follow applicable contract law due to an agreement that was made between the employees and the union, and employers and the union, and that the charge of unfair labor practices was therefore erroneous. Noel Canning also challenged the makeup of the 5-member board. They argued that the board did not have a quorum since 3 of the appointments of the board members were not approved by Senate confirmation and thus should be declared invalid. The court ruled as followed. The Court of Appeals determined that it didn't lack the jurisdiction to consider the unfair labor practice charge. They deemed that it was a state matter and not a federal matter. But the court did agree with Noel Canning that 3 of the board's members, whose appointments were made by President Obama as recess appointments, were invalid and therefore unconstitutional. The appointments were made on January 4, 2012, and these appointments were never confirmed by the United States Senate. Well, what happened since that? Lots of things, let me tell you. In the days following the ruling, Starbucks Corporation, which is the barista coffee kings of the United States, challenged the board, saying that they lacked the authority to rule on a case that Starbucks had pending before the board. Several other companies and even some unions have looked into having some rulings reversed as well. Based on the time frame of the appointments to the court's decision, there are about 600 cases that decisions that could potentially be challenged. The National Labor Relations Board and the Obama administration believe that the appointments made by President Obama during what he considered a recess of the United States Senate are valid and will seek an appeal of this ruling. Just what are some of the outcomes for labor? So the National Labor Relations Board plans to continue business as usual despite this ruling. The ruling will probably delay enforcement. The ruling by the court, though, will probably delay any enforcement of rulings made by the board until this issue is resolved by the courts. Some experts believe that this issue is the most significant issue the board has faced since the National Labor Relations Act was ruled constitutional back in 1937. Just what's the basis of the D.C. Court of Appeals ruling? Well, we have to look at the Bill of Rights, specifically Amendment 20, Section 2 to the U.S. Constitution. This amendment decrees that Congress needs to meet once a year, and that meeting should begin at noon on the third day of January. We also look at Article 2, Section 2, which Article 2 gives the President his powers, and in Section 2 says that the President has the power to fill vacancies that may happen during the recess of the Senate, which these are called recess appointments. President Obama made these recess appointments, though, on January 4, 2012. But the Senate was not in recess at that point, having the session started on January 3rd, as to what Noel Canning had argued and that the court had agreed with. The court ruled that these appointments were invalid because they were never confirmed by the United States Senate, which is, when the Senate's in session, this is what has to happen. Thus, the board did not have a quorum since 2 of the 5 members were valid members and the other 3 were not. To have a quorum, you would need at least 3 members or more to be valid members. What are some of the potential outcomes that we may see? The ruling of the U.S. Court of Appeals will potentially define the scope of the power granted to the executive branch of the U.S. government in Article 2, Section 2 of the Constitution to make the federal appointments. They may limit that ability to make recess appointments or clearly define what a recess is and when it should take place. If we look at Article 1 of the Constitution, which gives Congress its powers, Section 8 of the Constitution provides that Congress shall make the laws necessary to execute the powers granted in the entire Article 1. Rulings such as this may bring the agencies that are under congressional control more under congressional control, and they will no longer be considered the 4th branch of the United States government. There have been further developments in this case since this article was published. One such article, further development, which was highlighted in the Wall Street Journal in April, was that a bill had been passed in the United States House of Representatives by a 219 to 209 vote that would prohibit the National Labor Relations Board from taking any action that would require a quorum. This includes all rulings between employees and employers. This bill was introduced by Representative Phil Rowe of Tennessee and has 12 co-sponsors. The bill, though, doesn't seem to have much chance to get past the Senate. But there have been even further developments since that time frame. President Obama has introduced 4 new board nominees to Congress. The United States Labor Committee has forwarded this slate of nominees to the Senate to consider. However, the problem with the slate as put forth now is it contains 2 of the recess appointments, which caused the initial legal challenge in the first place. It is believed that these 2 board nominees will stall the process in the Senate because Congress is waiting to see what the court's going to say and how it's going to rule. There's been developments in the business world as well in this case. The United States Chamber of Commerce has joined Noel Canning Corporation in asking the Supreme Court to hear this case. President Obama's administration has put the case before the Supreme Court, and now the Chamber of Commerce is also asking for a ruling on this case. This is the first time that the Chamber is actually representing a member company before the Supreme Court. The Supreme Court could take this opportunity to help define the recess appointments, like I had said earlier. But there have been further developments in this case as well on the business front. Cablevision, which is a large cable company in New York City and State area, Long Island, so forth, is currently involved in a labor dispute with the Communications Workers Union. Cablevision has petitioned the United States Washington D.C. the Washington D.C. U.S. Court of Appeals, who made the initial ruling, the Noel Canning ruling, for a writ of mandamus. I don't think I'm saying that correctly. It's mandamus. That's probably how you say it. If you recall in Chapter 3, the case of Marbury versus Madison discusses the writ of mandamus. This writ is an order directed by the court directing a government official, in this case would be the National Labor Relations Board, to fulfill a duty. Cablevision wants the court to have the writ prohibit these complaints of unfair labor practices against Cablevision. Cablevision contends that the cost of their business because of these rulings are substantial, and they want to halt these practices so it can get on with business as usual. The National Labor Relations Board wants to complete the process of sitting with the administrative law judges and having the judges consider these cases and then go before the board before they reach a decision. Cablevision wants that process to be kind of zeroed out because of the board's invalid members. They argue that it's pointless to present the case before the invalid board. But they also contend that the writ of mandamus would send a message to the board that they can't just operate as business as usual, which they are contending they can do. The National Labor Relations Board has not even asked the court for a stay of the ruling while they appeal the decision. They contend that they don't need to follow the ruling. Cablevision is also seeking an emergency stay of the proceedings until the court can rule. So you'll need to keep an eye on this case over the summer as things are really happening and are really heating up. So stay tuned, and hopefully you'll see some legal action over the summer in front of the court, or in the fall, into the fall, in the next session of the court. I'm Rick Traffas. Thanks for listening. I will present the PowerPoint as well as a part of the presentation. Thank you.